Hey, you guys, good morning. So I told you I would be back when there were new filings, and this was actually dated for the 8th. So it came in at 10:20 p.m. last night. We know that Whitaker had things to do this morning. It is an order denying defendant Kendrick's motion for mistrial and supplement to same. So we're going to get into it. It's a blind read. Other than that, obviously we know that this was denied. And my prediction for it is, Doug Weinstein had that big juror recall issue. How can you ask somebody to forget Dumbo and not expect that they'll immediately start conjuring images of Dumbo? So 6 pages here, not that long. Let's see what she says. Before the court is defendant Kendrick's July 23, 2024 motion for mistrial, supplemented on July 31st, 2024. The court also considered the state's response, oral arguments by the parties, the transcripts of the June 7th and June 10th, 2024 ex parte proceedings, and the applicable law. Now, what is the state supposed to be responding to today anymore? Just curious. The motion for mistrial asserts 3 grounds for mistrial, with the supplement asserting a related 4th ground. 1, that it is impossible to redo the proceedings that occurred on June 12th, 13th, 14th, and 17th before the jury, in the interim between defendant's June 12th, 2024 motion to recuse the predecessor trial judge, and then his ultimate recusal. 2, that defendant's constitutional right to be present at a critical stage of the proceedings was denied. And look at me. Usually I gotta make this bigger. Let's stretch this out. Because I know if you're watching this on mobile, it is a tiny, tiny screen. There we go. So 2, that defendant's constitutional right to be present at a critical stage of the proceedings was denied when neither he nor his counsel were present for the June 10th, 2024 in chambers on the record ex parte discussions amongst the court, prosecutors Love and Hilton, counsel for witness Copeland, and witness Copeland himself. 3, that defendant's due process rights were violated when the predecessor trial judge allegedly aligned himself with the prosecution team by his comments during the June 7th, 2024 in court on the record ex parte discussion between the court and prosecutors Love and Hilton, and allegedly coerced witness Copeland into testifying during the June 10th ex parte meeting. Now, what's the pattern here? We keep specifying on the record. We keep specifying this. And 4, as raised in the defendant's supplement, that bias of the predecessor judge constitutes due process violations of defendant's rights under the constitutions of the United States and the state of Georgia. So what are you thinking so far? She's laid out the 4 things, which is really just supposed to be a summary, but she's using her language, choosing her language, emphasizing that this thing that we're going to be talking about is this thing that was on the record, which means we're not going to probably address what. Kendrick also asserts that the motion for mistrial was goaded by the state when it requested that the predecessor judge hold the June 10th, 2024 ex parte meeting, which has been the subject of much discussion in this case, absented Kendrick from that meeting, and joined with the predecessor judge in the coercion of witness Copeland. Now, we're addressing first the impossibility of addressing or redoing the proceedings post June 12th, 2024, which are void. Defendant Kendrick raises issues that the court has already addressed in granting defendant Williams' motion to invalidate and strike all proceedings that occurred in the above referenced case on and after the initial motion to recuse Judge Glanville filed on June 12, 2024. As noted in the order granting defendant Williams' motion, the court has been working with the parties on which testimony and evidence should be resubmitted/represented to the jury in this case. Well, as of the last 2 days, she kind of made the decision that it was all going to be stricken. And then, Steele kind of raised his hand and said, well, we don't really want that unless Copeland isn't going to testify at all, but then we would agree, strike it all. And then yesterday we heard a bit more clarification. Are there parts that people want to come in? There are bits and pieces of videos. Are we okay with just rolling with anything that may have happened after 3:30 p.m. on June 12th? So it's kind of weird that she's writing, we've been working, because she kind of made a decision for herself and then had to unwind it. But anyway, so what evidence should be resubmitted/represented to the jury in this case, and whether any other evidence at issue will be stipulated to, as well as any needed rulings and or instructions related to same. So we get a footnote. The order granting defendant Williams' motion noted that the court would work with the parties, and since that time, the court has done just that, formulating instructions, and addressing evidentiary issues with the input of all parties. So she did this yesterday. Yesterday she said she had completed her response to Max Shart, hadn't filed it just quite yet, but that she still hadn't finished her stuff to respond to Doug Weinstein's motion that we're getting this order denying right now. So yesterday she did do this, but she wasn't doing that the day before. As such, the court does not find that there is an impossibility to addressing these issues, and therefore, there is not a basis to grant defendant Kendrick's motion for mistrial on these grounds. The June 10th, 2024 ex parte meeting. And we get a footnote right away, right with the date. Defendant Kendrick's motion mentions as June 12th, 2024 ex parte meeting, which the court believes to be a scrivener's error, as the court is not aware of any ex parte meeting occurring on June 12th, 2024. Although that date is the date that Mr. Kendrick filed the motion to recuse Judge Glanville, which ultimately led to the current judge presiding over this case. So on June 10th, at the behest of Prosecutor Love, the predecessor judge held an on-the-record, in-chambers meeting, so on the record, with Love and stand-in counsel for Copeland, Caleb Bumpus, and Caleb Bumpus. June 10th, 2024, transcript is being cited here. Following a recess, at which time Love departed the meeting, Copeland and Prosecutor Hilton joined the meeting. Defendant's motion raises several challenges to this ex parte meeting. Did defendant have a right to be present, and did the ex parte meeting amount to coercion of Copeland's testimony? And did the predecessor judge's comments and participation in the ex parte meeting rise to the level of due process violations? So, I mean, wait. Okay, so we're getting a summary first, and now we're addressing each argument separately. I was like, wait, do we end here? So now we're first going to address the argument of the critical stage. The ex parte meeting was at a critical stage and violated Kendrick's rights. Now, this isn't a decision. This is referencing the argument that Weinstein made. Defendant argues that the June 10th, 2024 ex parte meeting was at a critical stage and violated his rights since he was not permitted to be present. A critical stage is one in which a defendant's rights may be lost, defenses waived, privileges claimed or waived, or one in which the outcome of the case is substantially affected in some other way. Brennan v. State. That's a Georgia case from 2022. Defendant is correct that this meeting was about more than just the parameters of Copeland's immunity and whether he understood its potential ramifications. Didn't she say the opposite in the response to Shart? She said in the response to Shart more than once that the subject matter of the meeting was the immunity and whether he understood the ramifications of the immunity. But here she's saying defendant, Kendrick, Weinstein, is correct that this meeting was about more than that. But okay. The initial stage of the meeting, before the first break, centered on the prosecution's concern with whether Copeland's main counsel was laboring under a conflict of interest. And we'll finish the sentence, but we have a footnote. And with the logistics of handling Copeland's testimony with stand-in counsel. So, footnote 3 here says the court sympathizes with Mr. Melnick's understandable indignation at having his professionalism and his loyalties to his client questioned. The court likewise appreciates defense counsel's umbrage. We had the same footnote in Shard's motion, in the response to Shard. Yeah, I'm not crazy, right? She did do that. This is in contradiction to what she said. Hold on. Let me post a quick rant on Twitter. I'm just going to post a screenshot. Isn't this in contradiction? That's annoying. I'm annoyed by that. Because it was filed a day apart. It's not like, oh, I forgot what I said. So anyway. But because these topics were all ancillary to Copeland's immunity grant, the topic of the meeting remained at its core. And as asserted by the prosecution, Copeland's immunity grant. Okay, so now it's mostly the topic, is how we're changing this. Come on. Come on. Thank you guys for making sure I'm not crazy. Because the meeting dealt with Copeland's immunity grant and its ancillary issues, it was not a critical stage of the trial at which the defendant had a right to be present. And she's citing Snyder versus Commonwealth of Massachusetts. So a Massachusetts case in another circuit from 1934, which was also cited in Shard's motion. Criminal defendant has a right to be present when his presence, quote, has a relation, reasonably substantial, to the fullness of his opportunity to defend himself against the charge, but not when his presence would be useless or its benefit but a shadow. And that's United States v. Gagnon. This might be a same paragraph pulled right from the response to Shard. The presence of a defendant is a condition of due process to the extent that a fair and just hearing would be thwarted by his absence, and to that extent only. And you heard me get annoyed yesterday about this argument, because in the previous motion, it was under the assumption that this meeting was just about Copeland's immunity and the ramifications. Now she's slightly expanding it to say it's kind of the core subject. But there's another problem, because they were saying that they were concerned about the defense hammering this witness. They were also trying to influence what Kenneth Copeland was wearing when he was on the stand to change his credibility. None of that's addressed here. So, to me, if the prosecution's actively trying to enhance the credibility of a witness, that's a problem for its own reason. But two, if the state is complaining that, oh, the defense is going to hammer you, we're not going to hammer you, but the defense is going to hammer you, it's like they're trying to obstruct the Fifth Amendment right to confront witnesses. So I really don't like this paragraph, and I didn't like it yesterday either, and I think trying to expand it last minute to say, oh, it was about a little bit more than that, but not address those specific details is really annoying. The fact that here discussions included what testimony would subject the witness to a charge of perjury, what would subject him to punishment for contempt of the order compelling his testimony, and what sanction might entail, even if incorrect, does not change this analysis. Well, speaking of incorrect sanctions, I don't know if I've ever heard of a proper remedy for prosecutorial misconduct being to take a class on Brady, when 40 witnesses have already testified. And if the judge says that we don't know that the prosecutors know what Brady means, how is that not a fundamental problem when over 40 witnesses were already called to the stand? Because how does the defense have the right, the confidence to believe that they had everything they needed to appropriately confront each of those 40 witnesses if the state, according to the judge, doesn't know enough about what Brady material means? Like, how do we go back to this? So speaking of sanctions, we give a mandated class on Brady training. But whatever, who cares about sanctions? Defendants' rights were still not the subject matter under consideration. The State v. Lowry, and what is this? Is this a Kansas case? No right to be present at hearing to compel witness testimony pursuant to immunity grant. We're going to get the same footnote here, watch. So we had this exact same footnote in Shard's motion. Lowry found that because the hearing there also included discussion and ruling on the defendant's motion, a mid-trial motion in limine regarding the witness using street names during testimony, absence of the defense violated defendant's statutory right to be present, though any constitutional error was waived. Here, there was no ex parte hearing or discussion of any defense motions. I got mad at this footnote yesterday. I won't rehash it. This analysis confirms that the key to whether the defendant has a right to be present for witness immunity proceedings is whether, for some reason, the defendant's rights are also a subject matter under consideration. Yeah, like the defense confronting the witness, hammering you. But whatever. So then we get a case from New York from 2009 that says ex parte meeting at trial court's behest between court, prosecutor, and counsel for witness, initiated after defendant and his attorney had left the courtroom during a recess at the close of the witness's direct examination, and held to ensure a witness understood his deal with the prosecution and that he was not unknowingly incriminating himself and understood his constitutional rights, held to be an ancillary proceeding dealing only with the rights of the witness, at which defendant had no right to be present. So this is straight up the same thing from Max Shard, the order denying Max Shard's motion. It's the same thing. It's like deja vu. So it's cases from other states. One of the cases from 1930 from another state, another circuit. Like, I didn't really think that this was necessarily comparable, but I didn't read the full case. The ex parte meeting was at the judge's request in this case. there was counsel for witness, and it was initiated after defendant and his attorney had left the courtroom. So, right, the parallel is defense isn't present for this meeting at a recess at the close of the witness's direct examination, and held to ensure that he understood his deal with the prosecution and that he was not unknowingly incriminating himself and understood his constitutional rights. But we just concluded that this meeting, this ex parte meeting on June 10th in this trial, didn't actually help the witness know how to not incriminate themselves or get their own rights trampled over. So I don't really know if I see the parallel here. The only parallel is the defense wasn't present. The predecessor judge improperly coerced Copeland to testify. So how are we going to get a response to this argument? And yeah, super copy and pasting, super copy and pasting. Separate from any defense right to be present for ancillary proceedings concerning witness immunity, defendant has a right to a trial free of coerced testimony. Defendant asserts that certain arguably inaccurate representations made by the prosecutors and the predecessor judge to Copeland about the law of derivative use immunity, the applicable statute of limitations, and this is the same paragraph from yesterday too, you guys, relating to what crime or crimes the defense does not specify, and the length of his possible incarceration for contempt coerced Copeland into testifying. Under both the federal and state constitutions, a criminal defendant has a right to be present during critical stages of his trial. That's Allen v. State. We have a Georgia case. Defense counsel should have been afforded an opportunity to attend any hearing where a sworn witness in a critical stage of the trial is being coerced to testify. Webb v. Texas says, Webb v. Texas is the touchstone for evaluating claims of coercion by the trial court of a witness's testimony. Archer v. State provides another example of a trial court overstepping its proper role of neutral arbiter and rendering involuntary a witness's determination whether to testify. Here, Copeland had the benefit of counsel, stand-in counsel. So we're not calling it stand-in counsel anymore, even though we did earlier in the motion. The predecessor judge did not, on the whole, use intimidating rhetoric, but rather sought Hold on. Because we don't have an audio recording and you weren't there. If I say something like, I don't know, what's a good example? Like you should put that down right now. And I'm laughing about it. And it's like someone's about to eat a cookie and they're on a diet and it's a joke like, girl, if you want to lose weight, you better put that down right now. Versus, you better put that down right now. And I'm ready to like shoot and fire at you because maybe I think you're threatening me, whether you are or not. How do you know if something's intimidating or not just by the text on paper? Especially when you have a witness taking the stand to tell you that that meeting had high emotional tension. But on paper, we're deciding that someone didn't use intimidating rhetoric, but rather sought to ensure that Copeland understood the nuances, which they didn't ensure that he understood. They ensure that he would say he understood the nuances of the decision he had to make. And he explained that many of the decisions about what could happen to Copeland were not his to make, but were up to the prosecutors. Still, some of the information provided to Copeland may have been inaccurate. Yeah, and what if you compare June 7th, where the state is rambling on and on about how they don't want to put him in jail, they don't want to take him into custody, but it's only up to them to put him into custody. Like, oh my God, guys. Oh my God. While it is likely that Copeland was not induced by any inadvertent or other inaccuracy to testify, the cleaner approach is simply to pre-termit this issue, acknowledging past inaccuracies and advise Copeland anew. This is the course that the court has proposed, and the parties have affirmed its efficacy. So we have this footnote. We kind of already saw the same stuff already, you guys. Copeland has since been recalled into open court on August 6, 2024, and in the presence of his counsel, Melnick, who was also privately consulted with and advised Copeland, was provided clarifying and correct information on matters potentially impacting his choice whether or not to testify. All parties were present and consulted with the court prior to Copeland being re-advised. And then, guys, we're not going to get that argument on the jury. On the jury actually being able not to recall something. She didn't address it. That was the main difference. Maybe she was like, oh, what can I copy and paste from my motion, my order denying Shard's motion? And then because she was looking for what she could piecemeal, she totally missed the point, the thing that was majorly different about Weinstein's motion. Because this is the end of it. And it's just addressing bias on the part of the predecessor judge constitutes due process violations. Put a 1 in the chat if you think it's important to explicitly address how you're going to ensure that you're going to make sure the jurors aren't thinking of Dumbo when you tell them not to think of Dumbo. Like, Doug Weinstein raised his voice about that. Oh my goodness. So we'll get this last paragraph. Thank you so much to Shatika for saying, shaking my head, I'm not surprised but disappointed. I hope Woody takes the 5th. Honestly, I think anything that Woody gets up there and does, unless he suddenly switches his entire demeanor, personality, everything, I don't think whatever he chooses to do is going to be beneficial to the state. That's the best I've got there, but I can't predict exactly what I think he's going to get up there and do. I do have some appreciation for Whitaker acknowledging that we can't be sure that he's going to testify and that we need to be prepared with other witnesses. I think it's hilarious that the state seems to have the same concern about witness Zachary maybe not wanting to testify either. So next week we might have 2 refusal to testify things to watch. It's going to be very interesting. Thank you so much for the super chat. Aaliyah, living my best life. Always good to see you. So you're the number one. You know, I won't say that. Guys, last night, I said, I'm going to rest. I'm going to relax. I'm really tired. LawTube Sean, potentially criminal is a YouTube name. X name is LawTube Sean. They do like a Thursday recap of a bunch of different news stories. And I opened the window and he was in the middle of reading the response to Shard's motion. He was fired up. He was screaming. He was going bananas. It was so invigorating to see. I love, love, love every second of it. The whole chat was posting bulldozer emojis. He has a custom emoji on his channel for bulldozers. And they're like, just bulldoze it all. All the judges are corrupt. It was just so refreshing. So I'm not the number one. I like to be learning from the people that I appreciate. And I appreciate that you're giving me the positive feedback here. I appreciate you. But guys, like, I can't believe we're getting a copy and paste here. And then Tebow says, 1, this judge is clout chasing and trying to restore the integrity of Fulton County and trying to curb the systematic racism with 3 angry faces. And I don't know. I think she thinks she's doing that. And if you guys kind of saw what I was saying yesterday reading the Shard motion, the response to Shard, she really treated... It's like she forced everybody that was present in that room, not Kayla, not Copeland, but she treated like, let's pretend Judge Glanville was me, let's pretend Simone Hilton was me, and let's pretend Adrian Love was me, and let's pretend Long was me too. And I wouldn't do these things because I know better. I know what an ex parte should and should not be. And because I wouldn't do that, I find it likely that they didn't do these things that they shouldn't have been doing. But I'm still going to make them take a class anyway. So I think you're kind of touching on a concept here of almost like a white man's burden, but ignorance to your own blissful ignorance, right? Like, oh, there might be a problem, but I don't want to look at colleagues as being the one that are participating in this problem. Because certainly they should know better. I've only had to tell them like 2 times in open court to take Brady seriously. I've had to define some Law 101 concepts. It's just, I don't know what she's thinking. I just got to call it blissful ignorance. Like she thinks it's a noble cause at this point and doesn't understand that she's facilitating the same thing, keeping the problem intact. But there's my rant. There's one of my rants. And then Tavisha, good to see you, says, can the defense get an immediate review? I for sure hope they ask for one. And don't forget, we have the order denying the disqualification request for prosecutors Love and Hilton. So hopefully there's a request for a certificate of immediate review on that regard. She denied that one a week ago when Steele was saying, hey, there's fatal flaws. I'm renewing this plea in bar. There's fatal flaws in the indictment. She denied his request, and then he requested a certificate of immediate review, and then she denied that request. So You heard me say for like 2 weeks, like, look, I just hope if she denies anything, she issues a certificate of immediate review. Certain things will seem more like an appellate issue, but give them the opportunity to fast track it in that direction, especially when you know the constitutional limits of, these people are sitting in custody. They've already been in custody. The outlook for this case is looking like April, maybe, optimistically. And then the appeal process would take even longer. So if you think you're concerned about their constitutional rights, why deny the request for a certificate of immediate review? While you're also saying this seems like an appellate issue. So we really need to sit here with our micro lenses here, see if she's requested and if she grants it. She hinted at it. It'd be weird for her not to, but she denied another one already. So great point. This is exactly what we should be watching for right here. So thank you, Tavisha. And then Chance says, Love and Hilton better thank DA Willis for having friends in high places. She has saved their bacon a lot. This is an unfair trial that continues, and they have the resources to keep continuing it. So that's the problem. So thank you so much, Chance. We'll get this last paragraph. I really can't believe she just skipped that whole poll thing. like the jury polling was a kind of a big focus of yesterday, all these jury instructions. You guys see it. How is this missing? How do you forget Dumbo? Is she trying to set the example like, oh, I read the motion, the argument about Dumbo, and I was able to not think about Dumbo? Like, what is the rationale here of not addressing that argument? Like, I don't know. So bias on the part of the predecessor judge constitutes due process violations. Based on the comments in the ex parte transcript made by the predecessor judge about counsel, both for the defendants and for witness Copeland, as well as about outside agitators, defendant asserts that the predecessor judge, during this conference, we have a footnote, revealed his partiality to the state. The footnote says the predecessor judge's remarks regarding outside agitators are virtually identical to the remarks he had just made on the same topic in open court, remarks which he addressed to all counsel, and which could not therefore logically include defense counsel. So, you heard me get annoyed about the same footnote yesterday. The difference here, she chose outside agitators to focus on, but she ignored all the context where on June 7th, Simone Hilton, Adrian Love, and then the judge all explicitly talked about Melnick, Max Shart, Brian Steele. So why don't we have Melnick in quotes here to say, well, when he mentioned Melnick, he had to be talking about all counsel. Or when they mentioned Max Shart, surely they were talking about all counsel. Or when they mentioned Brian Steele, surely they were talking about all counsel, not just defense counsel. We just hone in on this one quote. So to finish this out, she says that pre-termitting, this is the same paragraph from yesterday, the questionable accurateness of such characterizations and or discussions, this issue has been mooted by the recusal of that judge from this case. So wherefore, for all the foregoing reasons, defendant Kendrick motion for mistrial and supplement to same are hereby denied. And again, this was the 8th, so she sent this in yesterday. So there you go, you guys. There you go. There you go. Now, maybe there's more. Let me just refresh Twitter real quick. Let's see. Just an article. Yeah, so we're caught up. Hold on, let me just retweet this real quick. And you guys know the drill. If you guys use X at all, you're probably already following Thugger Daily. That's the first link. I feel like I don't see that much engagement on Joseph Papp's X account yet, but he does a lot of good updates and articles that include a little bit more context of the broader picture. So when there's a new motion, some of these articles will reference back how we got here or other things that are going on in Fulton County. So really, really, really good work from Joseph Papp. I should also link you guys to LawTube Sean's rant. Let me give it you can scroll to it by finding the timestamp on the screen. But it was good, guys. I'm telling you. The chat had bulldozers and everything. I mostly listened to it, but I remember looking at the screen and seeing a bunch of bulldozer emojis. Just get rid of Fulton County. All right, can I clip this with the... Yeah, because this stream was like 2 hours long talking about a bunch of news topics, like the 9/11 plea deals, and I don't know anything about that. All right, so here, I see. So I'm going to link to the timestamp here. It starts at 14 minutes in. I'm just going to call it Epic YSL Rant. So, totally worth it. And then I also see that Infamous Sylvia is she still streaming? I tried to set up a redirect. She doesn't let me redirect to her channel. She hasn't added me yet. But she did get permission. She will be in the courtroom at 8 a.m. Remember, you guys, they are going to be in the court at 8 a.m. Monday morning. Judge Whitaker said they have a bunch of stuff to sort out before they get things going. And Sylvia got permission to also be there at 8. So that's great. So we will be able to see what goes on. I feel like that's going to be a crazy 45 minutes. I feel like they're going to walk in there. Your Honor, I'm motioning. I need to make a request for a certificate of immediate review. Doug Weinstein's going to be like, yeah, me too. Shard's going to be like, yeah, me too. What are they going to get done in these 45 minutes? What are they going to get done? Who knows? And Christ Records 2016 says, so the next time I mess up in math, I can ask the principal Lola to send my teacher to retraining. Yeah, that's what we got to do from now on, you guys. Everybody just watch a video class. In fact, you know, the other day, Taybiz TV, you know him in the chat, but you probably know his channel too by this point, and you should. He did a video the other day on prosecutorial misconduct. Wouldn't it be funny? Just let them watch Taybiz TV's video. So the YouTube link I just posted there is a 45-minute video on prosecutorial misconduct that Taybiz TV put together. It features a lot of interviews from public defenders. But like, Christ Records, right? We could just make people watch these videos from YouTubers that seem to understand Brady material and ethics a little bit better than the people who have prosecuted dozens, hundreds of cases. That's just insane. But yeah, next time you don't feel like doing math, you mess up your math, just be like, teacher, it's on you. So go watch some training. Go sit somewhere for 2 hours. Thank you so much, Christ Records. And then Danny Bezo, is a judge not coming off as biased? Okay, so you mean, is she not coming off as biased? It's either that or back to the blissful ignorance. Like, she just can't comprehend that somebody would hold an ex parte meeting like that with a sworn witness and possibly talk about things off the record, because maybe she wouldn't do that or allow that because she's the judge, not, you know, counsel or for the state or for a witness. But as a judge, maybe she wouldn't have played that and can't conceptualize that somebody else would. But it's something. So it's either bias, maybe bias for peers, maybe bias for this. It has to be bias for the state too at this point. It can't just be bias for Glanville. Because the problems we're arguing don't even just deal with Glanville anymore. So I don't know. I don't know what exactly her bias is. It's like she just wants to live in La La Land. Like everything is rosy and flowery over here. So what is her bias against, though? Just the defendants in general? Or is it biased in favor of the state? Like, is she biased against, and that's why she's ruling this way? Or is she biased in favor, and that's what's making her rule this way? And squared, I guess that could mean on all four corners, so both ways. That's true. Yeah, so we're thinking with the prosecution. Anthony says bias for everything that happened before her, and her appointment, now she's trying to save their face. Yeah, so we've got both. So let's do with the squared corners then. The four squares, the four corners of the square. So we've got against the defendants, we've got in favor of the state, we've got both. We've got against the defendants. And then I see you guys are saying Fonnie Willis hearing this morning. Do you know what it's about? Thank you, Anne, for the super sticker. That's so nice of you. And for Russell for becoming a member. Mahadi Dehasu. Yeah, so this is past legal. It's political. I think so too. I think that's why I'm saying bias in favor of. And the defendants here are just a byproduct, right? The bias in favor of the state keeps the machine going, right? And it's weird because I feel like Whitaker probably believes she's doing some noble thing to fix a mess. But the mess can't be fixed. It can't be unmessed. We've got 40 witnesses that have already sat. They're done. They're off the stand. Not all of them are marked for rebuttal and would be called necessarily for rebuttal. So how do we cure the defense already having gone through cross-examination of these witnesses while we're re-educating the state, or maybe educating for the first time, on what Brady means and what Brady material comprises and what should be disclosed as Brady material to the defense if these 40 witnesses have already come and gone? How do we unmess that? The whole trial is a critical stage. Oh, this is good. What do you guys think of this? Beck Bixler says she is biased toward her own intellectualism. That's good. I think that's good. I think that's a good one. So wait, they're not going to poll the jury if Woody takes the fifth. You think so? Because wouldn't they, if he refuses to testify, then they would have to strike everything, which means they would need a new instruction that says disregard everything completely that you heard. Because that's the alternative to striking everything after 3:30 p.m. on June 12th, is to strike it all on the criteria, the condition that he ends up not testifying. So then they'd still have to instruct the jury to forget all of it, which I think is a harder task than just remember the videos we played you on the last half hour of the 12th and on the 17th, where you probably tuned it out anyway, maybe. But yeah, so I think they need to poll the jury either way, but I'm so surprised she didn't include this in her argument here. And then Jay Clyde says, she is trying to find a reason for mistrial that won't make Glanville look bad. He is still chief judge. This is Fonny's Hail Mary. And yeah, it could be. That's why I think it's a good point that this is, it might not necessarily be a bias in favor of the state in a bubble, but rather a bias in favor of the system, of the politics behind it, keeping everything moving. And yeah, I don't know. These this case I feel like there's been like an onslaught of like Hail Mary attempts. Just like that late disclosure, that late discovery relating to Agent Bernie and the cell location charting and mapping. We just suddenly want to mention that to the defense on Monday after Melnick and Kayla and Long take the stand. Where's that ethics guy that they called? Paul, was it Peter? Peter Herzog? Where's he at? Put him back on the stand and ask him, do you think it makes sense if the state needs to take a Brady training because they don't know what Brady is for a trial to continue when over 40 witnesses have already been cross-examined? Like, Megan, that's a great parallel. So this seems like after-school suspension for not turning in homework. Nothing to see here. Just keep it moving. CT Benny, the end-word show. Hold on, wait, what is the end-word show? Does that mean like you get the last word on your show? I need a description. She's biased and corrupt. Lady Justice wears a blindfold for a reason. And scales are balanced for a reason. Justice should have no gray area. Right is right. And I agree. I just don't understand how someone isn't able to see. Like, how do you undo this? I mean, she's really, these motions, especially since they're technically adopted by the other attorneys, she's essentially staring down Doug Weinstein and Jay Apt, Bruce Harvey, Mrs. Westmoreland, Keith Adams, Brian Steele, Carrington Matthews, like staring them all down and saying, no, you're wrong. Like, think about the intellect she's going up against just to say that the ideas they're putting forward, the arguments that they're making. She can't even decide that there's a gray area. She wagged her finger like one time in this motion, like, yeah, the prosecutors probably shouldn't have done that, but it didn't do anything. It was fine. So thank you so much, CT Benny. But yeah, that's a great point about justice is supposed to be blind. The scales are supposed to be balanced. And this is, well, I guess, how would you say? If it's tipped in the favor of the state would be lower, right? So this would be the state. It certainly is not balanced. Anthony Benny says, she's determined to go to trial. What happens during it, I think she may be more fluid and take ownership while covering Glanville and state's prior actions. And again, I still think the defense, this is the advantage, right? I still think the defense has the chance. I mean, it's difficult with this overt act concept and trying to explain and instruct the jury on what they're supposed to actually find. But as far as individual incidents, unless the jury, all 12 of them, are sitting there saying, surely they have to be guilty of these things, because why else would we be here for so long, right? That is a psychological issue that the defense has to kind of try to address. And you could see that they touched on that in their opening statements. But besides that, I do think there's a good possibility that at least one juror is sitting there like, how do you have these witnesses all coming in? They clearly took plea deals. They did crimes. Half of them are still in custody for something. And they got pleas relating to the same indictment. And that's supposed to be the word we take about the 6 people sitting in this room. So that's the only benefit here, I think, that's on the defense's side after all of this. Cool, she's determined to move it forward, but maybe it could end up in an acquittal for the defendants. But still a risk I wouldn't want to take if there's an injustice that should warrant a mistrial through the trial. Kenesha Fleming says, judges would rather appeal than judge-prosecutor mistrial. Yep, wants a different reason, if anything. Like, let it be on the jurors' shoulders. Totally agree. Thank you so much, Kenesha. And then Loving Me After We says, why can't Steele take this to the Georgia Supreme Court? They now had multiple motions denied for what's an obvious miscarriage of justice. So Monday morning, we need Sylvia in there at 8 a.m. sharp, because I feel like Brian Steele, I want to see it, runs in there and says, Your Honor, I want to make a request to this honorable court, and he's going to ask for that certificate of immediate review in relation to his motion about disqualifying the prosecutors that was just denied. So if Steele asks for that, and if it's granted, he can. If he doesn't ask for it, or if he asks for it and she denies that certificate, we've got to wait the long road for an appeal. So, but I totally hear you. It seems nonsensical. Just, it's like kicking the can down a decade rather than just the road of a year or two. So thank you so much for the super chat. And guys, like, I don't know. I feel like we still didn't really have many motions addressing the new stuff from June 7th, so I don't know. Oh, sweet. Let's pull up Doug's Twitter. Or did he tweet that? I'm assuming he was on. He's very active on X or whatever it's called. Okay, so here we have Doug Weinstein. And thank you so much. This is why I love the chat. Thanks so much for catching that. So here we are. Doug Weinstein said 49 minutes ago, the damage done by Judge Glanville and the state has infected the entire body of this trial. An emergency amputation of the judge can't save it. Nevertheless, we will continue to fight for justice and the eventual freedom of Mr. Kendrick. And then, what is this? Doug Weinstein is funny. Hold on, let me get you his Twitter, you guys. He is hilarious. So I'm just seeing this comment. This is a comment from someone named Shakia. I was under the impression that she wanted the state to respond by 5 p.m. today before she ruled on this motion. And Doug Weinstein says the state replied with it in quotes 2 weeks ago. So that's funny. And there we go. Can you ask for... There you go. Oh my gosh. Shout out to Doug Weinstein. Everybody put DW in the chat. Hold on, we need some hearts for him. This is awesome, awesome, awesome. There we go. And shout out to Shakia, because now this is how we got the tea. So, Shakia, wherever you are, thanks for asking this question. But yeah, he's typing that now. So there we go. There we go. Love you guys. Okay, I'm gonna put all these on the chat. I'm gonna clip this and send this to him. Look at all this love for Doug Weinstein. Typing up the certificate of immediate review. Like just straight down the chat. Yeah, we got a Dougie in here too. We have a DE, but I think we meant DW. Look at all, this is great. Yeah, so it should be filed. I mean, it'll probably be pretty short, I would assume, but if we see it uploaded, we'll look at it. There we go. Oh, I didn't share my tab. I get what you're saying. There we go. Sorry, boomerang. I'm boomerang through all this DW love. Look at it, still going. Still going. Yeah, we heart Shakia too, so I made you spell the name wrong because I didn't have it on the screen. But heart for Shakia too, for asking the question we all wanted the answer to. Look at all this. Awesome, awesome, awesome. It's going to be like a 5-minute clip of love for Mr. Weinstein, the Honorable Weinstein. There we go, you guys. Teach me how to Dougie. All the YSL lawyers are goats. There we go. And a Mario Kart in there too. Everybody's saying teach me how to Dougie. All right, we are going to clip this. So thank you so much. Shout out to Doug Weinstein. And there we go. And no court today, you guys. We'll be back at 8 a.m., remember. So, spread that word because people might tune in on 8:45 and a lot of interesting things could happen at 8 a.m. on Monday. And I don't know if a lot of people caught that it's going to be at 8 a.m. So spread that word. If you see a post somewhere, just reminder. I think a lot of people will want to tune in. So, and let's see, let's be nosy and look at his other replies, see if he said anything else good. Yes, okay, Red Bunny. There we go, Red Bunny. So shout out to Red Bunny because she's in this chat a lot too, always has great insights. I see her in different places in YouTube. And here she is pointing out, hey, Doug and Max, she contradicted herself in response to your motions. And Doug's going to reread the Stillwell order. Well, you can tell I'm old because I still try to use typeface smiley faces. But shout out to Doug, man. Shout out to these attorneys. Miss Esquire says, this sanction isn't enough. They should have also been ordered to write a letter of apology, referring to the fact that they need to take a class. Doug Weinstein says, I have trouble reading Crayola. So now we're going to have to use crayons in the chat when the state files a motion. We're going to have to put crayons in there from now on. Is there anything the public can do? Doug says elections have consequences. Doug is funny. Oh, and a bunch of attorneys yesterday, different attorneys. Doug had said if we don't get a mistrial in YSL, this was yesterday at 4 p.m. Eastern, I may have to go to Brad W.C. attorney for help as co-counsel. I know he's a workers' comp guy, but we need to shake things up. I also believe 3-year Letterman would approve of bringing up on his cousin. Phil Holloway wants to come on as an 8th chair. So there was like all this love here. A bunch of attorneys jumped in on this saying that they want parts. I would like to 3rd chair behind Brad from Anthony Michael Crease. GSU, who's also got great commentary on X. Let me drop that in the chat. GSU has great commentary. They're all like, we're in, Doug. We are in. So No, well, this has been really, I think this has been really kind of cathartic to read Doug Weinstein on X. Social media is important. It's not just garbage and fluff. I think it was a bit remotivating to read this from Doug Weinstein. So we're gonna wrap this up. I do have a super chat that came in that I want to get to here from. Okay, so Mahadi de Jesus says, do you see Whitaker using the 13th juror to overturn a jury not guilty verdict? I don't think she can do that. I don't think she can turn over an acquittal. I could be mistaken, but um but I believe she can only turn it over if it's a finding of guilt. I don't think she can do it if there's an acquittal. I feel like that would just be a huge, huge violation of the defendant's rights if a jury acquitted somebody and the judge tried to overturn it. I can't imagine there's case law out there that says that that's okay. So I don't think so. I don't think she can touch the verdict. She has power to potentially set aside a verdict if there's a finding of guilt, if she has a basis for doing so, and if the defense moves to do so. But I don't think she can turn over an acquittal. But you always have good insight, so you're making me question myself. But I'm like 99.9% sure she can't overturn an acquittal. And then, thanks for the super chat. And then Anthony Benny says, Kat, I stumbled into your account due to this trial. Instantly loved what you and the mods do. Shout out to the mods. Drea's birthday is like right around the corner. Because I think she's 6 hours ahead of me. So, I don't know the exact math. But she's probably like 8 hours, 9 hours away from it being her birthday, finally. So shout out to Dre. I don't know if I've seen her in the chat yet today. But I'm glad you appreciate the mods. And shout out, loved what you and the mods do. Great community, fun and informative. By the way, thank goodness for cameras. Yes. Thank goodness for cameras. Especially to hear that intonation of the voice, right? Because we can't tell if rhetoric is intimidating or not just by the words on paper. The context helps. So great points you're making here. And then Cash Money Cast, great point about the Karen Reed trial. I think they're doing oral arguments later this afternoon in about 2 hours, 2.5 hours for the motion to dismiss. And that's going to be really interesting because there's jurors that came forward and signed sworn affidavits that all of the jurors were unanimous that she was not going to be found guilty. They were going to acquit her on the top charge of murder and also fleeing the scene. They just weren't sure about the middle charge about, driving while under the influence in general. Which, if you watch that trial, it seems like everybody on that night that drove was driving under the influence. So, but there is no actual polling of the jurors to say, all right, we can't come to a unanimous decision. They didn't ask what was disagreed upon, what they were hung up on. So I believe the defense is going to be making oral arguments today at 1 p.m. If you guys are interested in that, I will probably be in Andrea Burkhart's chat. She is great. She does a lot of appellate work in the state of Washington, but she will be covering that hearing. So, at least I think it's the hearing. I think it's oral arguments. Perhaps we're just reading the text. And then Will Bowman says, I hope the appeals court hammers. And we gotta love the word hammer because the state was like, oh, the defense said they're gonna hammer Woody. I hope that the appeals court hammers all judges and prosecution involved in this case. They should be very upset and that their time has been wasted. Yeah, so, but they don't care because their resources can just keep going on and on and on and on and on. So they're going to keep wasting the time. And I'm not sure the appeals court, when they're not asked expressly to address an issue of, maybe speedy trial or something like habeas corpus, if they're not asked explicitly to address those issues, I'm not sure how much an appeals court considers the time something takes. unless the specific issue is the time. So maybe they'll decide to be upset about the time on their own, but I think they kind of look at most things in a timeline bubble. But I wish that would change, because that could, judges don't want to have in a record where they're constantly reversed by the appeals court. So if the appeals court tightens up, it could get some of the judges to do a little bit better. But yeah, so okay, cool. So a lot of people are going to be covering Reed. Okay, that makes me think it's a hearing for sure then, if a bunch of people are scheduling. So Andrea Burkhart is her name. I'll drop that link again. But yeah, if it's a live hearing, I'm sure a lot of people will be streaming then. And then Hiron says he's a high-powered... Oh yeah, okay, so you're talking about Martin Weinberg. Oh, so Martin's going to be doing the argument. Oh yeah, I'm definitely going to be in that chat watching. For sure. For sure. But the prosecution's determined to retry on all charges, you guys. That's the issue. And then Wins is saying that 1 and 3 were dropped. Were they dropped? I don't think they're dropped. I think this argument today is about those 2 charges. I don't think this argument is just about dropping the remaining. Her attorneys are still fighting for 1 and 3 to be dropped. And then let's see. Are there any more open motions? I have a notification here, you guys. This is a shout out to the chat. Look at you guys get a shout out. So shout out to the chat for understanding what Brady is more than Adrian Love and Simone Hilton. That's what's up. That's all you guys. And I can pull up the portal that hates me. No cases match my search. Did I type the wrong case number? All right, let's try this again. Oh, I had the YouTube link there. Okay, wait, we're getting a bunch of, these are the transcripts, I think, from June 7th, 10th, 11th, and 12th. Because there's 4 of them. So there are some more filings, but it's just the transcripts from those days officially being filed. Let's check under Doug. And then Flowgrown, thanks for the super chat, says you should cover the Sarah Boone case. I know Excited Utterance is covering that. A bunch of people have. I think Legal Vices is covering that. I'm trying to think of whose thumbnails I've seen on screen this week. I haven't had time to actually watch anything, but I see the thumbnails when I open YouTube. But I'm close to that. So that's going to be in Orlando. So if there aren't going to be cameras for all the hearings, I can actually go. I can actually go and make sure we know what's going on. So that'd be really cool. But Sarah Boone is another interesting one because she's defending herself pro se. So no filing yet for that cert of immediate review. And then I think this is still just the order from yesterday. Okay, yeah. So, oh yeah, and I gotta remember, we can't just say this order for Shart was an order denying his motion. It was just an order on the motion because we didn't want to deny verbally. We didn't want to deny someone's motion for a fair trial. So it's just an order on it. So I should be accurate about that. But thank you so much again, Flowgrown. Sarah Boone case is interesting again because she's pro se. I know she had one hearing. I think, does she have another hearing today? Garrett S. Don't let us forget that Steele got 20 days for criminal contempt. Under appeal, not yet dismissed. The DA, of course, plays loose with evidence and due process and gets sentenced to training. Yeah, hold them in contempt for their misdoings. I totally agree, and I would love to see it. And who would show up for them? Who would show up like Ashley Merchant and Alex Souzer and 25, 30 others showed up? It'd probably be Fonnie Willis and Adam Abady. And then Will Bowman says, what I mean is that there are very clear and obvious rights violations throughout this case. A reasonable judge should have thrown it out. I think she's trying to put blinders on to what's behind her. But she's got to see that in this 2 weeks, there's already been issues. Like, that's insane to me. So I agree with where you're coming from. I just think she's so convinced she can look forward. And it's frustrating. And I don't know, like, just thinking about the way that she... I think we should all take Brady very seriously. So seriously that we order a class. Like, it just doesn't match the energy. So I'm with you, Will. Thank you for the super chat. And then Key says $4.99. I'm curious to see how she judges during the trial and how many objections she sustains and overrules for the state and defense. Well, and I think that's going to be entertaining because we're going to see the state get flustered, especially when Love is doing the questioning. I don't think Love has the temperament to have objections against her sustained. She wrote a whole motion in limine mid-trial back in June to raise a fuss about, oh, I don't like the way the judge is sustaining the defense's leading question objections. Well, if you're asking a leading question to your witness and the defense objects and the judge is like, yeah, that is a leading question, like, you can't just make a motion in limine in the middle of the trial, try to reverse that just because you want that to be your way. So what I don't think we'll see from Whitaker is, oh, Love wants me to let her questions fly just because she wants them to fly. I don't think we'll get rulings from Whitaker about, oh, it's fine if you ask leading questions. Oh, it's fine if you're, introducing facts that are not in evidence through your own questioning rather than letting the witness testify, making herself an unsworn witness. I think, and maybe I've got rose-colored glasses, but I hope we at least, bare minimum, don't see that happen. So I'm just as curious to see how the judge judges during the remainder of this trial if we're moving forward, and how many objections and how she sustains or overrules objections from each side. So I'm totally with you, Key. Key. But yeah, we're all caught up, you guys. What are you guys gonna watch? Oh my gosh, shout out to Shakia. We're doing Shy. Oh, maybe so it's Shy Kia. Is pronunciation 2 right? Because you're going by Shy for short. So Shy Kia, maybe. But this is our girl here that asked the question to Weinstein. We had the heart given some chats for you earlier. I don't know if you were here yet, though. The Honorable Shy. Shaika. Okay, got it. Shaika. There we go. The Honorable Shaika. And then, yeah, a bunch in the chat are saying we're going to watch the Fonnie Willis hearing. Where are you guys streaming that, by the way? Because I see Sylvia has it up on her screen. So Infamous Sylvia is still live streaming. And she's going to be streaming the Fonnie Willis hearing. So there's one option. Here was Andrea's link that I had for Karen Reed. Oh, Olympics are good. I don't know. I haven't watched the Olympics on a channel or stream. I just keep seeing clips on Twitter. There's so many clips. And then I'm not getting any other. I do see one Sarah Boone stream coming up on my For You page. Everything else on my For You page is like music. Music and gaming. And then here's some Sarah Boone stuff. With excited utterance. Is Dearwood Christian live? Let me go to my subscriptions tab. Oh, he's doing the Senate hearing. There you go. So you guys have a bunch of choices. I'll probably see you hopping around. I got some work to do, so I might be quiet in the chat, but I'll at least try to say hello. So I'm glad you guys are all over here. And oh, EDB. Okay, now that I typed Karen Reed one time, I got a bunch of Karen Reed. So Legal Vices, Karen Reed. This is like a diner of options, you guys. And then Emily D. Baker. And there you go. So a bunch of choices. And there we go. Don't forget the Honorable Shaikia. I can't even find Shai in the chat anymore. Shai, I don't see you. You're on my screen because of X. But shout out to Shai one more time. And there we go. We will wrap it up, you guys. Have a good time wherever you go to watch after this. See you next time there's something filed. And if it's just going to be a request for a certificate, and it's like one page, I'll just make a community post. But I'll tweet about it too. You guys all have a good one. And there we go. There we go. Shout out to Shai. You guys all have a great, great, great Friday. You guys all have a good one.